Okay, so moving on, we've got a few more things on the modernization piece, and we'll talk about prompt payment. And just so everybody's aware, the slides will be distributed to everybody who's given us your information. So the information, there's a lot of information and a lot of detail in these slides, highlighting sections and language of the statute, so you'll get that. We're just trying to highlight the key points, key changes for you. Anybody a landlord or do work on leasehold improvements here? There are some new rules that are coming applying to leasehold interest. Right now the Act does not automatically give a lien right on the underlying fee simple, on the underlying premises of the landlord when you're doing construction work for a tenant. There's a process that can happen, but it doesn't happen automatically, and the landlord has the right to discharge or avoid any kind of liens attaching to its premises. That won't be the case anymore when there is any kind of funding or credit or rent abatement for leasehold improvements. So typical tenant improvement allowance will automatically trigger lien rights for the benefit of the contractor on the premises of a building. So that's a very new change, and it also ties in with the Section 39 disclosure obligations. Landlords who provide leasehold improvement funds of any kind, and that's very broadly defined, will also have to answer to contractors' requests for information about the status of the lease and the payments for that leasehold improvement. So that's a bit of a change for landlords. As Stuart mentioned, and clear from some of the things we've been saying, there is a much heavier use of forms. There's actually 18 brand new forms that are created. A lot of these have to do with these notice of non-payment and certainly with the prompt payment regime. But it is a more formal and formulaic and prescribed form statute now, including a new notice of lien form. Right now, a notice of lien does not have any kind of prescribed form, and it's often a question of whether this letter that I received is actually a notice of lien or not for the purposes of the Act. That's now going to be prescribed form, so you'll know very clearly whether it is or not. So if you have adopted or used or incorporated into your systems and your documents any of the existing standard forms that are part of the statute, you'll have to update those, even if it's just to reflect the fact that the name changed. Every form is going to have to be updated for that and for other reasons. Other relevant changes, as I said, there is a lot of changes. We've listed some of these here. I didn't mention earlier as well, the definition of substantial performance is being changed slightly. It's being updated. As those who are aware, Section 2 defines substantial performance with two tests. One is a functionality test. Is it ready and built for the intended purposes? And that doesn't change. The financial threshold test, though, which is based on the contract value, that moves up from $500,000 tiers to $1 million tiers to reflect the fact that there's been a little bit of inflation since 1983. I mentioned this one earlier. Right now, the notice of termination. So they added the expiration of the lien rights is tied to the last day of supply of any work or materials, substantial performance, or abandonment. They are now adding termination. But to make that work for calculating the lien period, they now require a notice of termination. So this is a notice that actually is not just delivered to an owner by a contractor or a contractor to an owner to a contractor. It also has to be published. And so it's designed to start that clock ticking, and so it needs to be published so subcontractors are aware that the lien period has started and the clock is ticking. But there has some clear unintended consequences of that. Right now, you can have a dispute, and often you'll have a negotiation settlement period. Somebody's going to throw down a notice of termination at some point, and then it escalates finally up to the CEOs of the company. They come to the table, they work things out, and then everybody gets back to work sometimes. That's not going to happen anymore because you've now published to the world that this contract has been terminated. So it'll deleverage the use of any kind of threats of notices of termination because once you've published a notice, your subcontractors aren't coming back to the project site. Your lenders are going to start to accelerate any borrowings and trigger any defaults under their lending agreement. So you're really cornering yourself once that notice gets issued. Liens will no longer attach the premises of a municipality starting in October 1 of next year, and they won't attach to public highways. There's some procedural changes for notice of liens on condominiums, an easier way for unit holders to discharge. I'll just highlight Part 8 of the Act deals with all of the different construction dispute procedures. We're not going to get into the details here. First of all, most of those rules and procedures are moved into the regulations, so they're more easily updated later on. So if you're looking for them, you got to look to the regulations. But there are some changes there too. You can now combine, without the need for leave of court, you combine a lien claim, trust, and a contract dispute claim. You can bring small lien claims in small claims court now. And construction claims are going to be case managed. So there are a number of changes to procedures for claims, and there are also a number of technical amendments, as I said, forms and different processes. So there are a lot of changes, and it does merit having a look at those if you're deeply involved in using the Construction Lien Act regularly. Certainly, I think a lot of this is only going to be learned in the real life project when you're faced with the actual consequences of a claim or any procedure. So we rushed through some of those changes at the end. As I said, some of these are summarized in the slides, some of them are in our materials that are on the website, but there are a lot. Most of those will need to be learned, but once you've learned them, there's not a lot more you just have to move on, and that'll be part of our new world. I do want to get on to a prompt payment, because this is a regime change. This is going to be a culture shift. Essentially, there's a new bottom line in construction projects. Owners are going to have to pay within 28 days of receiving a proper invoice, and contractors will then have 7 days to pay their contractors once they've been paid. So Canada's a bit of an outlier when it comes to prompt payment. Most jurisdictions out there, 49 states in the US, Australia, UK, France, and others have some form of legislated payment regime for construction payments. We will now have that in Ontario, and I can tell you, if you work nationally, it's coming across the country. Already there's a Senate bill federally. There's a private member's bill that was introduced a couple of weeks ago in Manitoba. 3 provinces have law reform commissions looking at this, and others have committees or other sorts of review of prompt payment regime that's being introduced in Ontario. So my view is within 5 years, we're going to have prompt payment and possibly adjudication across the entire country. So we need to get ready for it, even if you're just, if you are looking at projects outside of Ontario. So let's, first of all, does this apply to me? Yes, it applies to everybody. It applies to everybody in the construction pyramid, all types of projects, public, private, conventional, P3 projects, new build, repair, your home bathroom renovation at home, to the construction of a hospital. So these new rules will apply to everybody. All sizes. There was some attempt to exclude small projects and very, very large projects. The government decided, no, everybody's in. And these will be these will apply to all payments made under contracts entered into or after the day the prompt payment provisions of the Construction Act come into force, which will be October 1 of next year. Can you exclude payment provisions? No, these are mandatory. They're binding. You are allowed to structure your payments. So you, instead of having monthly progress payments, you are allowed to, for example, put milestones into your contract. If it's defined clearly in the contract that you've got milestones and you've got criteria for determining when those milestones have been completed, that's okay. Once those milestones have been completed, though, that's when the clock will start ticking, the 28-day clock. So that's how that will work. What you're not allowed to do is require a certification of the work or an approval by the owner of the invoice or a draft invoice before it gets submitted. So this is a bit of a change. We often see, especially when project financing is involved or some other large project, we'll see the draft invoice has to be submitted first, owner approves it, or the work gets certified by the consultant, and then the final invoice is submitted, and then the clock starts ticking. That's reversed now. You have a proper invoice that gets submitted without the certification or approval beforehand. That happens within that 28-day period. So that tightens things up very, very tightly. So let's break this down a bit. So first of all, it's a proper invoice. This is a defined term. This is one of the places where the province decided not to legislate a form of invoice. They do leave that to the parties to negotiate what other conditions and criteria, what, WSIB certificates, insurance certificates, whatever you want, that's all allowed as a condition for submitting your invoice. But there is a definition, a description of what a proper invoice must at least include as a minimum. So you want to make sure you're complying with that. And secondly, an owner is allowed to dispute payments. They just have to dispute it within 14 days of receiving that proper invoice. If they want to shortchange on an invoice because they think there's deficiencies or the work hasn't been completed fully to the extent the contractor claims, that's fine, but they need to provide a notice of non-payment within 14 days of receiving their proper invoice from the contractor. Not only that, but they have to issue this notice in the prescribed form. It can't be just an email or a letter. And they have to state all their reasons, and they have to give details. And that will become important in the adjudication that Mark is going to talk about in a few minutes. If you've not included all your reasons and you try to introduce new reasons in front of an adjudicator, I expect the adjudicator will say, I'm not listening to you, and you're stuck. Now, this doesn't mean you lose your right to dispute a deficiency if you miss the time period. You're just going to have to pay, if you miss that 14-day window, at the end of the payment period, you're going to have to pay the full invoice and raise the set-off on the next invoice cycle. So it defers, but think about it for a second. If you've got some kind of project funding and you miss your notice and you find out on the 20th day that you've got a deficiency, your lender's not going to advance the funds, but you're going to have a payment obligation. So you've got a real gap there, and you've got to find the money somewhere. It's not good enough for the lender to say, well, we'll just pay me the full advance now, and then we'll draw a shorter amount next month, because the lender wants to know that the work's been done properly. So we've got a bit of a gap there. And you must pay any undisputed portion on that 28th day. So if you don't get your notice in, or if you're disputing only 25% of an invoice, you still have to pay the balance of what you don't dispute. Similar rules apply to the contractor. First of all, if they are paid, they must pay their subcontractors within 7 days, unless they deliver their notice of non-payment within that 7-day window. So and a bona fide reason for not paying is that I haven't been paid, or I've received a notice of non-payment from the owner, and so you're not going to get your money either. Their notice is in prescribed form as well, and they have to set out all the reasons. That should say the 7-day, not 14 days. And they also must pay any undisputed amount. So it seems like pay when paid, and that's what the Vogel-Reynolds report had recommended. But in fact, it's not quite a true pay when paid. For contractors, if they get paid, they have to pay within 7 days. However, if they don't get paid by their owners, there's a 35-day period that starts from their proper invoice, at the end of which they have to either pay their subcontractors out of their own pockets, or they have to start a fight with the owner. They have to commence an adjudication. So that's a bit of a change, and it puts pressure on the contractors and the likelihood that we'll see a lot more adjudications so contractors can avoid the obligation to pay. So there is a definition in 6.1 of a proper invoice. We don't need to go through that there, but that is the definition. You'll want to make sure any form of application for payment or invoice you have meets with that description. I'll point out item 7, any other information that may be prescribed. When the regulations came out, nothing else was prescribed, so you're just looking at the whole definition there. So what happens if you don't pay on time? Either a contractor doesn't or an owner doesn't pay within the stipulated times. First of all, interest is going to start to accrue, statutory interest at a prescribed rate in the Courts of Justice Act. You are allowed to agree to a higher amount, but you are not allowed to agree to a lower amount than what's in the Courts of Justice Act. Secondly, if you don't pay and you go to adjudication, an adjudicator renders a decision, a determination, and you still don't pay, you're giving your contractor a statutory right to suspend work or terminate your contract with costs, and certainly costs for remobilization as well. So we now have the contractors and subcontractors with a very powerful statute-enforced rule and right to terminate if they're not paid. This can't be waived in contract. That's prompt payment. It's very tied up with adjudication. And so now we'll move to Mark Crane, my partner Mark Crane, who's at the back coming forward now, who's going to talk about adjudication for the next couple of minutes. And these rules, prompt payment and adjudication, are coming in next year. These are the kinds of things that we think need some very thorough looking at. After Mark speaks, my partner Chris Stanik's going to step up and start to talk about some of the practical things that organizations need to think about when it comes to prompt payment and adjudication and all of the other changes.